This podcast is brought to you by Customplan Financial Advisors, Inc., an independent insurance managing general agency in Canada. Financialpodcast.ca was developed with one goal in mind: to educate Canadians on important topics that affect their financial well-being and make it readily available to all. We welcome you to plug in and learn with us. If you have questions, please email us at contact@financialpodcast.ca.
Welcome to today's podcast. This is Dennis Roberts with Customplan Financial in Calgary. Today we have Lynne Butler from Butler Wills and Estates in St. John's, Newfoundland. Welcome to the show, Lynn.
Thank you. Glad to be here.
So why don't you, before we start, why don't you give a bit of a biography or a bit of a history on yourself as to how you got into what you're doing so that our listeners can understand your background?
Sure. I graduated from law school a long time ago. I've been in this business now for 32 years this year. I have always worked in what we generally call the wills and estates area. So wills, probate, adult guardianship, powers of attorney, and a fair amount of estate litigation. So I've been working on those, like I said, for over 30 years. I practiced for a long time in Alberta and came back to Newfoundland in 2012, and I'm now practicing here. I've done quite a bit of writing about wills and estates. My 10th book is coming out this fall, and I'm active in a lot of wills-related activities, such as the bar admission course in Alberta and here in Newfoundland, and seminars and that kind of thing. And I blog quite a bit. I've been blogging at Estate Law Canada for about 9 years. And so I'm quite involved in the whole area.
Well, that is interesting. Now, I see you've also done shows with CPAC and BNN and CBC Radio and Global TV, so you're not a novice to this.
No, I've done quite a bit of radio and some TV as well, and have had interviews with a lot of newspapers like the Wall Street Journal and Globe and Mail and newspapers right across the country.
Well, that is good. So anyways, today what we're going to be talking about is, and a lot of people that I know of do this, they add their child's name to their home or their bank account as an estate planning tool. Now, why do people do that to start out with?
Well, it's something that they've heard about, and it's something that's easy to do, but the goals that they're trying to reach are basically to avoid having to go through probate or to reduce probate fees. They are trying to keep things simple. They think that, the idea is that if they put their child's name on something as a joint owner, they pass away and the child takes the asset. And that's sort of what they're going for, is that simplicity. They sometimes think that it means they won't have to make a will if they put things jointly with people. And, those are sort of end goal type of planning things. Sometimes when it's a bank account, they're thinking about things like their mobility is becoming restricted and they want a little bit of help getting around. And I hear a lot of people say things like, I want to make sure the kids are going to have some money when I pass away if my assets are frozen. The kids will have money for my funeral. And so there's a whole range of things. And it's a sort of do-it-yourself type of approach that it sounds good and it's easy to do and it doesn't cost money. So it seems like a good solution for people.
Now, is there a risk that's associated with doing this?
There's actually a lot of risk. And, whenever I do seminars and I start talking to people about this kind of thing, and I ask, is there anybody in the room who's done this kind of thing already? And there's always 2 or 3 that sort of very shyly put up their hands and say, yeah, we've already done that. And it's everywhere. People have done it everywhere. But what they don't realize is they're assuming that nothing's going to go wrong between them passing away and the child getting the asset. What they're not doing is looking at the things that can happen. So the risk that's out there is a risk to the parent. For example, if you've added your child to your home, and so now your child is a joint owner, and then that child gets divorced, all of a sudden that child's assets are being split with his or her spouse, and they own your house just as much as you do. There's none of this, it's really my house and their name's just on it. They own it just like you do. So there's a risk that you could lose your house or your bank account or your cabin or whatever the asset is that you put a joint owner on, because of something that happens to your child. And one of the things that people say to me all the time is, well, my kids would never do anything to hurt me. And I'm sure that's the case, but your child may not have control over these things that are going on. The child may not have control over whether he or she gets divorced or whether there's a business failure or whether they're being sued for something. They've had an accident and they've got $1 million in public liability and they're being sued for $3 million. These things happen in life and the parent is bearing all of that risk.
Well, that is certainly true. I mean, sometimes we think that nothing will go wrong, but things do go wrong occasionally. And like you said, there is a lot of risk there, or there's a considerable amount of risk that really needs to be taken into consideration.
Yeah, and I don't think, hoping for the best, keeping your fingers crossed is a very solid plan. People really do need to realize it's okay to hope for the best, but you have to plan for the worst so you don't set yourself up for situations where things can go wrong. And to me, this adding somebody to your assets this way, most of the time, is setting yourself up for a problem.
And then to even further complicate it, if you added one child and there was 2 or 3 other children that weren't added, that has the potential to cause some family issues as well.
It actually causes an immense number of issues. The thing that happens is a lot of times the other people, the other kids, don't necessarily know the details until mom or dad have passed away. And then the reaction quite often is one of suspicion of how did they get mom or dad to do that? Why would mom or dad suddenly decide that this one's going to get the house? And it creates that kind of suspicion and defensiveness, and it pits the kids against each other. Whereas when I talk to people about what their goals are of estate planning, having the kids remain friends and remain a family at the end of the day is usually the top goal. And yet they're taking steps on their own that could well create the opposite effect.
Well, I can certainly see how that could happen.
You are listening to financialpodcast.ca.
Now, are there any tax consequences in setting up a joint account with your child?
There can be. It's more when it happens on property, on real estate, simply because of capital gains tax. If that child already owns another property, so your house is his or her second property, and now your house is coming out of the estate, it's being sold, there's going to be capital gains tax on their portion because their half of the house is not your principal residence, which would be tax-free, and they've already got a different principal residence of their own. So all of a sudden now they're going to pay tax on that transfer of the house, whereas if it had been left in mom and dad's name, there would have been no tax at all. So it creates, and this is where when you think about avoiding probate and probate fees, you have to think, how much would probate realistically be in my province? What a number am I planning around? And when you think about the cost of litigation and the cost of capital gains tax and that kind of thing, you're really gambling with such a small number for a large risk.
Absolutely. And, and I know people that have inherited a cabin and had to end up selling it just to pay the taxes on it.
Yeah, that's right.
So what was supposed to be a gift to them actually turned out to be quite the opposite.
Yeah. And, I find that the best estate plans are the ones where people sit down and they don't, the goal is not to make a will. The goal is to set up a plan that involves your house and your life insurance and your investments and everything, and just have a big discussion about what is actually going to happen or what could happen, and what are the tax consequences going to be, and how should we set things up in terms of beneficiary designations. And sometimes that means that a financial advisor or an accountant or somebody else is part of the process, not just the lawyer. But if it all works together, then it's going to go well.
Another question about all of this, is this a legal option, or are we kind of playing with, in the gray area?
Well, that's the real kicker of it, is that it doesn't really work in terms of avoiding probate anyway. The goal, if you're trying to keep assets out of probate by adding your child's name to it, that doesn't really work anyway. It used to be in the old days that a joint account or a joint property was joint and the survivor always got it. That's no longer the case, and it hasn't been the case now for 10 years. It's applied very inconsistently across the country, but the law does say now that if a property is owned between a parent and a child, and we're talking about a property that was originally the parent's and then a child was added. This works for real estate or for accounts. If somebody's added to it and then the parent dies, that does not go automatically to the child. It's held in trust for the estate until it can be established with written evidence about what was the intention of the parent. Did they intend for it to go to the child as right of survivorship, or did they intend for it to be part of the estate and it was just done for convenience? And so then, you think you've simplified things and you think you've avoided probate, but you haven't. You've actually created more problems, more processes and more costs and more everything. So it's not a legal option.
So in this case, it's even more important than to have a will.
It is important to have a will. And one of the things that I do with wills with people who say that they've already added one of their children to the property, I have a discussion with them about their intentions for that property. Why is it in that child's name? Is it for the child? Is it just to keep it out of probate? Why is it there? And I will confirm their intentions in the will in the hopes of preventing some kind of hearing or process or something, or a court lawsuit that they have to go through to decide what to do with that property.
You are listening to
financialpodcast.ca.
So that in the event that a parent did leave or brought one of the children in as a joint owner, would a will trump any joint ownership?
Generally speaking, no. Generally speaking, joint ownership will trump a will. But when it's the case of intergenerational, it can be the other way around, simply because of that rule that we have to know the parent's intention. And if the parent has a will that says, I put this in my child's name for convenience only, this is part of my estate, then the will is going to trump that joint beneficiary designation and say this now belongs to the estate, not the joint owner. So it does kind of depend on the facts, but the key to it is that intergenerational component.
Well, that is good to know. So can then a parent's goals be achieved through their wills?
Yeah, sure. You can put, for tax purposes and other reasons, and simplicity, you can leave the house and the cabin and other things in the parent's name, certainly with the principal residence at the very least. And then try to be a little bit more creative in the will. If you're thinking, I would like one of my kids to own the cabin, I'm not sure which one it's going to be, so I'm going to put everybody's name on it. That's a bad idea. Instead of that, you could, for example, say, look, the child who uses this the most is Johnny. So I'm going to put in my will that Johnny's got 60 days to exercise an option to take the cabin or the house or whatever it is. And if he doesn't do that within 60 days, then something else will happen or somebody else will have the option. So, you can do more than just say X gets my house, right? You can set up some parameters and some guidelines for people and some suggestions. So you can do a lot of that through the will. Another thing you can do through the will is talk about if somebody does get a taxable asset, are they paying the tax or is somebody else paying it? So you can work through a lot of the issues that they're going to come up against and then resolve them ahead of time in the will. The stronger the will, the better the will, the more help that it gives the executor and the beneficiaries.
Absolutely. And so the more detailed as to who gets what, right down to heirlooms being assigned to different individuals, it's probably a good idea to be very detailed in all of that.
I agree, because a lot of times there's also confusion when you're talking about somebody putting a joint name on the house. There's an assumption that also includes everything in the house. And of course it doesn't. But it's when people have different ideas about what words and phrases mean and what different gifts are that you end up in court.
Well, that's good advice. So now, is an enduring power of attorney useful as an estate planning tool, or for parents, with adult children like that?
Yeah, it absolutely is. It's very underutilized in my view. When a parent adds a child to a bank account, a lot of times they do it because they want help with the banking, or they want to say, in the future, I might need help with the banking, so I'm going to put one of my kids on there to manage things for me. And so the goal is to provide the child with access on your behalf. But when they add somebody as a joint owner, that's not what they're doing. What they're doing is they're giving the child ownership. So say, for example, that child gets added onto mom's account that has $100,000 in there. And the next day it's down to $5 because the child has taken off with the money. What can that parent legally do when the day before they added them as an owner, giving them the right to take the money? And what can you do? You've given it away. You've given ownership. So to me, the better solution is, if what you need is someone to access your money for you, that's what an enduring power of attorney does. You don't need to give them ownership of your money to get help with it. So, there's lots of forms of power of attorney. If all you want is someone to help you with one bank account, go to the bank and fill in their form that deals with one bank account. If your needs are different and you need that general enduring power of attorney that covers all of your assets, you can have that. I mean, it depends on what your needs and your goals are. But to me, I think it's a risk to give ownership when all you really want to give is access.
I can absolutely see that. So now, if there's more than one child, could both of them have the power of attorney, or do any transactions that were required jointly, or is that kind of complicating things?
You can have more than one. And, of course, it depends. Everybody's situation is different. But it's certainly possible. I always find that siblings don't make very good work partners, whether it's executors or powers of attorney. But every family is different, but it's possible.
Yeah, it's exactly. I mean, it opens the door to a lot of family conflict, or it can have the ability to do so. So, now, do you have any other advice for us as to for estates and setting up and working with your children, or just some general estate planning?
One thing that I do like to tell people is, rather than go around and you see something like a joint property idea and you say, hey, I could use that. That's kind of doing things in reverse. That's kind of seeing a solution and then seeing if you have a problem that fits it. I think the approach should be, before you start doing any do-it-yourself things, sit down with a planner, whether it's a lawyer or a financial planner or your accountant, whoever it is, sit down and determine what your goals are. Then you can figure out what tools are available to reach those goals, as opposed to sort of piecing and cobbling together a bit of this and a bit of that, and you've got things that contradict each other. Just sit down with one person that you trust and has some experience and define goals first, solutions second.
Well, that is good advice. So why don't you just give us a bit of a plug for yourself as to how someone can get in contact with you and utilize your services?
Well, as you said, we're in St. John's, Newfoundland. Anybody who's local can reach us at 709-221-5511. We do one-time consults on the phone, actually, with anybody anywhere across the country, or sometimes out of the country. Sort of a one-time where we're not leading into, a lawsuit or anything, just to chat. We do that. People can see us online at www.butlerwillsandestates.com, and they can see my blog at estatelawcanada.blogspot.ca.
Well, thank you, Lynn. It's been a pleasure, and we'll look forward to having you back again.
Great. Thank you very much.
You're welcome.
The views expressed here are those of the participants and not those of Customplan Financial Advisors, Inc., its affiliates, or subsidiaries. This is not intended to serve as a complete analysis of every material fact regarding any company, industry, or security. This presentation may contain forward-looking statements. Investors are cautioned not to place undue reliance on such statements, as actual results could vary. This site and podcasts are for general information purposes only and does not constitute investment advice and is not intended as an endorsement of any specific investment product or service. Individual investors should consult with an investment professional about their personal situation. Past performance is not indicative of future results. If you are unsure about what is the best course of action for you in your financial planning, then we suggest you consult a fee-based independent financial advisor or get in touch with us to discuss your individual situation. Our phone number is 604-687-7773.